Dr. Abhishek Manu Singhvi. He's the senior Congress MP and one of the country's leading lawyers. He joins me. Appreciate your joining us, Dr. Singhvi. In passing these three important legislations, Dr. Singhvi, new criminal laws, the Home Minister says he's ending a colonial legacy, that the Bharatiya Nagrik Suraksha Sahita has Indianized a colonial legacy of criminal laws. Do you accept that this was a much needed reform in our criminal justice system?
Rajdeep, what has been done, far from being much needed, is not required at all and is retrograde. What a law does is what matters, not rhetoric about colonial laws. A colonial law may be good and your modern law may be bad. And if the reverse is true, then the former must be amended and substituted by good law, not because it is colonial, but because you're bringing something good. This is a classic case of cosmeticism at its worst. Khoda pahad, chuya bhi nahi nikli. And I will demonstrate to you immediately why. What was required, first of all, very, very cosmetic, much more so than you think. What was required by way of structural, of course, laws require reform. They require autonomy, not done at all. What is done in many, many ways, of course, I can't cover all the examples, is retrograde. And it is really but a ego-based namkaran naming exercise.
No,
you must leave your imprint on everything. You must leave your identity on everything.
Dr. Singhvi, sorry to intervene. The fact is, you're using words like retrograde. You're saying it's cosmetic, it's ego-driven. But let's turn to specifics. Forget the rhetoric. We want to focus on the law itself. Now, for a long time, Dr. Singhvi, you know that those in the criminal justice system, whether police officers, judges, lawyers, all of them have been calling for reforms. The government says this is part of the reforms, and they claim that police powers are actually being controlled, will not be arbitrary, and the laws itself are more citizen-centric. Can you tell me, when you say retrograde, be more specific?
So, Rajdeep, the devil and God both lie in the details. Let's take them one by one. Let me give you straight away 3 or 4 genuinely needed structural reforms not done. And let me then give you 4 or 5 done which are retrograde. Now, you mentioned just now police reforms. That's one of the, so this is actually a lost opportunity because of rhetoric and namkaran and, ego. Police reforms have been talked about in innumerable law commission reports by 3 Supreme Court judgments called Prakash Singh, etc. The simple point there is separate genuinely by Chinese walls, Chinese not fashionable now, so Indian walls, the prosecution part and the investigation part. Have you done it? You lost the opportunity to do it. I would have welcomed it. You have the fantastic example, of course, an extreme example of the district attorney in the US. You have the director of public prosecutions in England. We have those posts intra-department, but they are meaningless because there is no genuine separation. And that, what suffers is objectivity, transparency, and impartiality. Just take an ordinary IO. You are a journalist of very senior repute, Rajdeep. You know what a poor IO does? He gets up in the morning,
information
he goes
officer
into the field and collects evidence. Obviously, he gets attached to the limited evidence he collects. By 12 o'clock, he lands up in some court to do evidence. Comes home in the afternoon, comes to the office in the afternoon, sits in his own department with some seniors to decide whether the evidence he has collected should be prosecutable or not, and then files a report in the court. Now, this is completely apart from, of course, this is apart from doing his boss's bidding and, doing menial tasks. Now, this is completely the antithesis of a good police department. They should have, as a first reform, not done, missed opportunity, made these walls between the collection of evidence and the decision to prosecute. Then, of course, the second one is to make it much more reformative, not punitive. Increase the number of compoundable offenses. There are innumerable number of petty offenses which are not compoundable. Impersonating a public servant, some petty organized crime. I'm giving only examples because I don't have time to go into the details. But that is a reform I would have welcomed. Punishment alignment. You'll be surprised how many offenses are serious, but the punishment is minor. And vice versa. Align those things. For bribery for elections, how much is the punishment? 1 year. And because you have an agenda in the love jihad, you've made a new offense, which I'll come to on the retrograde category, of 10 years. Riots provocation is 6 months. Do these arraignments. Of course, this part I must end by telling you one good thing they've done on this. And the good thing is that they've brought in community service as a punishment. I welcome that. I only say there that that list where you can award community punishment instead of incarceration should be increased to many, many, many more offences. But of course, should be excluded for second, third time repeat offenders. Both these last two things have not been done.
You're using the word retrograde again and again, and you used it interestingly just now in the context of love jihad, which you say could result in 10 years. They don't explicitly use the word love jihad in these new laws, but could result in 10 years of imprisonment. Could you give me an example, similar examples of why you believe these are retrograde? What is it about the way they've been formulated that you believe makes them retrograde?
4 examples, and I'll be very brief because our time is limited. And these are 4 out of many, many more. 1, there is a section 69 added, or a clause 69 still be passed. Sexual intercourse by deceitful means. Humongous, disproportionate 10-year punishment. Astonishingly, the parliamentary committee which reported on it has put it under the head, appreciated provisions leading to involving love jihad. So clearly this is a disproportionate new offense intended for a particular agenda of the government. If you must have it, you already have rape by deceitful means. You don't have to have a separate offense with a 10-year punishment. And you know the laxity of prosecution, how you can be selective, how I can punish you and let off somebody else. 2 major problems. And I've, for the life of me, not found the method in the madness, Rajdeep. Anti-terror. You know there's a UAPA, that is an older special law. It is directed and focused against terrorism. It has the 3 principles on anti-terror law which are harsh, but which are used for anti-terror. Reverse presumption of innocence, bail more stringent, and statements admissible. Now in this, you have created a separate anti-terror part of this law. The funny part is that you have let it be decided by an SP as to whether you should apply the UAPA or this law. So the SP can pick and choose. The powers under UAPA are more draconian, more harsh in favor of the prosecution. You have now a parallel system, and a SP chooses, and worse, that SP chooses without any statutory criteria specified. I can't understand the meaning. Either you make some amendments to UAPA which exists, or scrap UAPA, it's even better, and make it more humane, as partly you've done in this one. But having both, some hidden agenda, I can't find a reason. Exactly the same thing has happened with a slight difference in anti-organized crime. You know that all these states have these laws, Kakoka, Makoka in Maharashtra, Haryana, Punjab, Rajasthan, my state, all of them have these state laws. They have similar stringent provision of reverse presumption of proof, bail, and anti-bail, more stringent on bail and admissibility of statements. Now you've gone and created again a similar code of the mega all India IPC, now known as BNS, for an anti-organized crime law. Now again, there is no method in the madness. First, unlike the anti-terror provision, there is no provision telling you whether the prosecutor will choose the state law or this law. He would normally prefer the state law, which is more stringent. It will allow selectivity. It will not tell you whether Rajdeep should prosecute me for which reason under X and prosecute somebody else under the other law Y. There is no criteria specified, which is given in the anti-terror part of the BNS. And the worst, Rajdeep, I say it in a lighter vein, the government is of course not guilty of sedition. It cannot be. But it is guilty of betrayal. On 11th May 22, as far back as 1 year ago, the Supreme Court put a stay. On 24th of October 23, 31st of October 22, they reiterated and recorded the statement of no less than the Attorney General saying we are seriously reconsidering. Suddenly, 1 year later, on 24th of May 2023, the Law Commission comes up with a direct recommendation for sedition, and the government interestingly distances itself, says we don't know, this is a Law Commission, it's an independent body. That of course was meant for those who eat grass. But then now, in this law, it is nothing but the same sedition law. Mr. Honorable Home Minister is wrong when he dresses it up as Deshdroh and not Rajdroh. That one, the earlier one, had life for 3 years. This has life for 7 years. It's the same law reincarnated. And more than that, after Supreme Court assurances, what is the weight of your assurance to Supreme Court in future if you act like this? And one last thing on this, you know the actual practice on the ground. You are arrested in Gujarat by Assam police on sedition charges. You're a journalist in UP and you are booked up in sedition charges. And everybody will give you a lecture and a sermon. Oh, if you have a good case, the law will take its own course. You will win. Not telling you that the process is the punishment. It's good enough to stay in jail for 3 to 6 months, and then of course you'll get some relief sometime.
You know, Dr. Singhvi, I respect your legal acumen, which is why I allowed you to look specifically at this. But, you know, you started this by saying that this is a missed opportunity for the government. But the fact is, it's a missed opportunity for you as well. You could have debated this in Parliament. Instead, you're part of the group now, which of MPs which are suspended. The disruption of Parliament has meant that the country has been denied a wider debate. You want to lead that debate.
Rajdeep, personally, I am anguished because on a lighter vein, I am the only male who has been aborted twice. I was the lead speaker last session on the Election Commission bills, aborted. And this session on these 3, I was opening the debate today, aborted. But ask the question, for what is this happening? For a simple statement by the Home Minister of the country or the Prime Minister of the country about a parliamentary breach. So who is showing ego? Who has a preconceived agenda that, look, A, we will function from the mountaintops with ego and not budge an inch. We will not give a statement, though we'll speak about it outside. B, the moment you protest about why you are not speaking, we will go to the extreme step of suspending you. C, have placards never come in Parliament before? But have you had 141 suspensions ever before, except one incident of 69 people for a totally different reason? 4, you are happy to go along each day and decide this in an empty Parliament. Might as well not have Parliament in this debate. So you have to decide who's to blame. We are not doing it joyfully. I am fully prepared to argue this today. I was going to be the lead speaker at 2 o'clock. Do you think I'm very happy at missing it? But if you do Tanashahi, dictatorship of this kind, and you expect us to come into the House and say, okay, he will not make a statement, but the House should not listen. What have you not listened to us? The smallest possible request which should be given for the asking in the last 75 years of parliamentary history, minus 40, minus 10.